Are you ready to begin? Yeah. Okay. I will now call this Committee of Adjustment meeting to order. We'll begin with the land acknowledgement statement. Before I start that, I just want to make sure everybody can hear me. All good? Okay.
All good.
Thank you. In the spirit of reconciliation, we acknowledge with respect the history and living culture of the Anishinaabe, the people of the Three Fires, known as Ojibwe, Odawa, and Potawatomi Nation, we who have inhabited this land from time immemorial. We recognize that these lands are the territories of the Chippewas of Sagin and the Chippewas of the Nawash, collectively known as the Sagin Ojibwe Nation, the keepers of this land. Jordan Bluffs is located on land encompassed by treaties 45.5, 67, 72, 82, and 93. We reflect on our role as treaty people and the need to live in respect and peace and show respect to the First Peoples who inhabit these lands and waters. So moving on, we will move to the approval of the agenda or any additions. The agenda be approved as presented. Can I ask for a mover and a seconder? Moved by Member Glenn and seconded by Councillor Moore. Is there any discussion? Okay, I will call the vote. All those in favor? And that is carried. Moving on to item number 4, declaration of pecuniary interest. Are there any declarations to be made tonight? Nope. Okay, moving on to the minutes of the previous meeting. Can I ask for a mover and a seconder, please? Moved by Member Glenn and seconded by Member Moore. Is there any discussion? Please go ahead, Councillor Moore.
I just wanted to note that there, for those members who did not attend that meeting, there's nothing there to document that. I'm accustomed to seeing either members that sent regrets or members who were simply absent. So I suppose this is a request of the minute taker that we do not only note those present, but also those who weren't here and whether they sent regrets or are just absent.
Okay, thank you very much. Can we ask for those minutes to be updated to reflect which? Okay, perfect. Thank you. Moving on. Okay, so we need to call the vote on the minutes for the last meeting. All those in favor? Right, that is carried. Item number 6 is new business. Can you please go ahead, Michael?
Thank you, Madam Chair. Couldn't find my my microphone to turn myself on there for a second. I am very pleased to announce that Ben Sukamal is our new community planner working for the township. Ben comes with a bit of experience here. He was our co-op planner here for a couple of terms at least, and Ben most recently comes from us from the City of Kitchener and the Grand River Conservation Authority.
Thank you.
Welcome, Ben.
Welcome aboard, Ben.
Okay, we will,
Thank you.
moving on to item 6.1, new applications. So 6.11, development application 2025-067, the consent application B1525 for Breen and the Bruce Trail Conservatory. This meeting is of the Committee of Adjustments to consider the applications for a consent for Jeffrey Breen and the Bruce Trail Conservatory. Under Section 51 of the Planning Act, Mr. Secretary Treasurer, please go ahead with your review.
Thank you, Madam Chair. There have been no requests for deferral or withdrawal of the application. Notice of this application in accordance with Ontario Regulation 197-96 made under the Planning Act was given on August 22nd, 2025 by mail to all property owners within 16 meters of the property, which is subject to the application, and to all the required agencies. Notice was also posted on the property and on the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary-Treasurer of the Committee. Only a person or public body that requests a notice of the decision of the committee in respect to this proposed severance may submit an appeal.
I will now read the recommendation that it has been demonstrated that application B1525 for Jeffrey Adam Breen for lands described as TP Brook Part lots 41 and 42, Township of Jordan Bluff, County of Grey, is consistent with the provincial planning statement, conforms to the County of Grey's official plan, and complies with the intent of the Township of Jordan Bluff zoning bylaw, and does not conflict with the Niagara Escarpment's plan. It is recommended that the application be approved subject to the following conditions. 1, that a reference plan be completed and a copy filed with the municipal clerk or an exemption from the reference plan be received from the Land Registry Office. The reference plan should conform substantially to the sketch that's included as Schedule A and filed with the application for consent. 2, that pursuant to Section 5342 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of the giving of the notice of decision. Note, Section 5342 of the Planning Act requires that the transaction approved by this consent must be carried out within 2 years of the issuance of the certificate. That's stamping of the deed. Number 3, that the applicant pays the applicable consent certification fee at the time of the certification of the deed. 4, that the payment of the balance of any outstanding taxes as the date of the certification of the transfer deed with respect to the property that is subject to report development 2025-067 roll number 420-358-00-120-3810. Can I ask for a mover and a seconder, please? Moved by Councillor Moore Colwyn and seconded by Member McMillan. Could the planner please give us a summary of the planning report regarding this file?
Thank you, and through you, the chair. So the purpose of application B1525 is to sever a 1.98 hectare parcel from the existing 4 hectare parcel to facilitate the creation of a lot which is intended to be protected for conservation purposes and will be managed by the Bruce Trail Conservancy. The retained 2.02 hectares containing a dwelling and accessory structures will be continued to be utilized for residential uses. With regards to relevant consultation pertaining to this application, notices of the proposed severance was issued on August 22nd, 2025, and comments have been received from the County of Grey planning staff indicating that provided positive comments received from the Conservation Authority regarding the potential hazard lands, county planning staff have no concerns with the subject application. So as of today, we have received additional comments from the Grey Sauble Risk Management Office, indicating that from the information noted in the application to sever a portion of the property for conservation and retaining the remaining for residential use, it has been determined that neither Section 57, prohibited activities, nor Section 58, regulated activities, applies to the above property pursuant to the Clean Water Act of 2006. Consequently, no policies apply to the activities identified in the application under the approved Source Water Protection Plan for the Saugeen, Grey Sauble, Northern Bruce Peninsula Source Water Protection Regulation, effective July 1st, 2016. However, it is important to note that the above property is located within the event-based area for the Owen Sound drinking water system, whereby fuel storage greater than 50,000 liters is regulated. And those are the extent of the comments received to date by planning staff here at the township. Thank you.
All right, thank you. I will now call upon the applicant to provide comment. Please state your first and last name for the record prior to beginning.
Good evening. My name is Joel Swagerman. I'm with the Bruce Trail Conservancy. It's a pleasure to be here this evening with you. I don't really have anything to add to the fulsome report that your planners have written, but I'm happy to answer any questions or concerns.
I don't have any questions, but do any other members have any questions for Joel? No. All right, thank you, Joel. No members of the public registered to provide comment. I will now call, oh, we didn't have any, so I won't. Do we have any people that showed up last minute? No? Okay. Are there any points raised by the planner, the applicant, or the public that the committee wishes to respond to? Okay, please go ahead.
Thank you, Madam Chair. I had sent a question into planning staff that they responded with a draft condition to be included in the decision. I noticed in reading of it on the motion, it wasn't included. I would like to put it as an amendment to the recommendation that the conservation easement be registered on the property as part of the recommendation. I think I think we have written wording that will be included in that.
Oh,
I believe you're muted.
sorry. Yeah, please go ahead.
Perhaps it might be better to address or see what Councillor Coburn has to say first, and then I can read the motion.
Thank you. I was going to suggest the same thing, the reading of the amendment. I guess we're voting on the amendment before we vote on the motion, and I would be happy to second that once you've read that, Michael. Thank you.
Okay. And with your indulgence, Madam Chair, I will read the proposed motion.
Yes, please go ahead.
That prior to final approval, the applicant shall register a conservation easement on title for the severed parcel to the satisfaction of the Township of Georgian Bluffs. The easement shall restrict future development and ensure the long-term protection and stewardship of the land for conservation purposes.
And we will need, do we need a vote or?
Yes.
Okay, so all those in favor? Okay, that is carried. So we've added that motion. Do we still need to call the vote on the application? Okay. So with this motion passed, okay, Joe has his hand up.
Sorry, if I may, was this in the report or this amendment, the conservation easement?
No, I'll let Michael go ahead and answer that for you.
Thank you, Madam Chair. The idea of a conservation easement was actually brought up by the committee members after the report was published.
Okay, through you, Madam Chair. We have done before covenants on title to restrict development, but because this property would not have frontage and it's owned by the Bruce Trail Conservancy, who is a land trust only interested in conservation land, a conservation easement is it's a little bit redundant, and I'm just not sure if it requires a separate consent or is that part of the same consent? Are we talking about an easement or a covenant on title? I guess I need some clarification.
Michael, can you answer that, please?
Certainly. And through you, Madam Chair, to Joel. It's my understanding that the easement would be registered as a covenant on title. It would not require a separate severance application or a consent application as you normally would for an easement that would convey rights to another property owner or something like that.
Okay. If I may, Madam Chair, through you, so it'd be registered on title as an easement in favor of the township.
If I may, Madam Chair, it would be perhaps the conservation easement, being the word easement, is not the best use of that term in this instance. It's the conservation easement is, or that restriction is a way to restrict any future development occurring on that property. So it's and perhaps Member Glenn can correct me if I'm wrong, but I would tend to think that it's not. I suppose it might be registered in favor of the township, but the purpose of it is to restrict any future development on the lands.
Member Glenn, did you want to speak to that at all?
I'll speak to it. The conservation easement is typically through to the township to put restrictive covenants on the land to ensure that it remains for conservation purposes. So that in the event that the conservancy decides to sell the property, we don't have a piece of land that's landlocked and they're coming forward asking for development. We now have an ability to say we have a conservation easement on the property, and the municipality would have the ability to say, no, we're not removing it.
I understand. Thank you for the explanation. Much appreciated.
Okay, and I saw that Councillor Colborne had your hand up. Did you wish to speak?
I'm becoming a little more confused about this as well. Like maybe it is the word easement, but typically you'd have an easement if there was access required by someone other than the person who owns it. But if the biosphere owns that whole parcel, then I guess I'm confused as to why an easement would be required as well. And then just secondly, I'm not sure that we've done this with other packages that this group has purchased for the purposes of conservancy, and perhaps our representative Joel could speak to that. But I'm not so sure that we've gone through this same process with other lands acquired by the same organization. So I'm wondering why this one would be different.
I don't know, maybe Michael can clarify this. I do believe we had something similar, actually not too far from this location, last year or the year before. And I can't recall if we did the easement or not.
If I may, Madam Chair, we did the last application that we had, I'm quickly trying to look it up here, was related to Ducks Unlimited lands. And I'm just going to look up that application to see how that was addressed. We addressed it a little bit differently by putting the holding symbol on the property. For a zoning amendment.
Okay. I'm not sure what is the appetite for the committee. Do you want to continue forward as we have with the motion as read and vote on the file, or do we want some more discussion? Councillor Coburn?
So what are the material differences between the holding symbol, Michael, and labeling it an easement? What are there any material differences in the two down the road, or from the perspective of the purchaser at this point in time? I'm just wondering what the differences would be.
Through you, Madam Chair, to Member Coburn, the differences are essentially the approach between the two. Putting a holding symbol on the property is a zoning tool, and so you would have that holding symbol recognizing that something would need to happen for that symbol to be lifted. For the Ducks Unlimited one, they require ecological assessments and some other matters for the holding symbol to be lifted. The lands were also already zoned as environmental protection, so that in itself limited future development on it. Those lands also did have road frontage, so that was a little bit different with that one. With this one, with the conservation easement, that is directly registered on title, and as Member Glenn noticed, it's registered in favor of the township. Essentially, what that means if the Bruce Trail Conservancy, for whatever reason, ever wanted to or had to sell those lands, then somebody purchasing those lands would have that restriction essentially written right to the title of those lands, and they would then have to approach the township to try to lift that easement, and the township would very likely say, no, we're not lifting it because the intent of those lands is for conservation purposes.
Any further discussion from committee members? Okay, we will go ahead with the vote. All those in favor as the motion is stated and for the file. Okay, so I see 2 hands, so that is carried. 3 hands, okay. I think we're, okay, I will ask for a mover and a seconder to end this public meeting. So Member Glenn and seconded by Councillor Coburn. So thank you. This public hearing is now adjourned. Item number 8 is the next date of our regular meeting, which is October 21st, 2025. Member Coburn, please go ahead.
I'm just wondering if we skipped over new business 6.1.1.
Oh, you know what? We did. So we did new business. It's 7.1 that yeah, sorry. Okay, back up. So item number 7, unfinished business. Thank you, Member Coburn. 7.1, correspondence from Brent Thompson, 7th application B0525. Can I ask for a mover and a seconder to receive the correspondence? So moved by Member Coburn and seconded by Member McMillan. Is there any discussion? Member Coburn?
So I'm concerned that this property owner has not been given due process. It appears to be our misstep in that the website was indicating in-person attendance. And it sounds as though this individual was waiting to be part of that discussion at the office and was not able to. So I guess my question for staff, I suppose, is have we met the requirements of us by inadvertently, denying isn't the right word, but you know what I mean, the inopportunity for this individual to be able to speak on his behalf at the previous meeting. It's just not sitting right with me. So I'm wondering from a process perspective, how we make this right.
Michael, are you able to speak to that?
Thank you, Madam Chair. I can try. I think in a matter like this where you know, our notices do mention that the meetings are virtual attendance. The website, you're correct. Member Coburn is not as clear. Perhaps in just to in all transparency, perhaps the matter could be brought back to the committee for consideration. That would require a 2/3 vote of the members who were in attendance at that meeting to decide whether or not to bring the matter back. If that vote failed, then perhaps another motion that would ratify the decision of that meeting might be in order.
Member Glenn, please go ahead.
Yeah, I just have a question on that. So our hearing was quite some time ago. Has notice of decision on that consent been given?
Michael, please go ahead.
Through you, Madam Chair. No, notice of decision on that consent has not yet been given because we're bringing it back to this meeting, regardless of the correspondence, just to verify the decision of refusal. That decision wasn't really it was implied, but it wasn't provided through a formal notice at our last meeting. So just to clarify things, I wanted to bring that recommendation back to this meeting to verify that decision. And then in the meantime, this letter came back, so it was an opportune time to bring both back.
I'm just gonna bring up a question. Member Glenn would be like there's deadlines that when notice of decision need to be recorded and distributed, correct?
Have we lost Michael?
I'm not sure. I'm kind of moving.
No, I'm
so I
sorry.
thought it was me.
I'm sorry. The minutes of that previous meeting are the minutes that would have come tonight to this meeting. We did not have a meeting in August, and that's why things are a little bit delayed. But the minutes of that meeting are at tonight's meeting for ratification by this committee, and then once those minutes are ratified, as they have been ratified by this committee, then they'll be published.
Member Glenn, please go ahead.
Yeah, this is along the lines of your question, Madam Chair. My understanding is that we have made a decision on the consent application. There are statutory requirements for notice to be given. And are we compounding the problem with this severance by saying, first off, if there was an error on notice and they didn't get to participate, are we now making another error in regulation under the Planning Act of not giving notice for them to be able to appeal within the statutory time frame underneath the Planning Act? And what does that do to the application? I guess that's a roundabout way of asking Michael, are we in trouble with the application itself because we didn't give notice under the prescribed time frames under the Planning Act?
Actually, through you, Madam Chair, I think about we likely are. There's the hearing was held on July 15th. A decision was made at that hearing. We have as staff, we have 15 days to provide notice of that decision out, and that decision was not brought within those 15 days. So technically, yes, that would be an additional error on this one. I believe the letter that came from Mr. Thompson kind of compounded that a little bit, and I at this point, either we move forward with a formal decision on the matter, or bring it back to the committee for reconsideration.
Member Glenn, I know you're going to say something. Go ahead.
I'll let Councillor Coburn go forward, or Committee Member Coburn go forward. And
Okay.
I'll speak again.
So I feel like Member Glenn ought to have the floor here because of his experience and my lack thereof. But it seems to me that if we're already offside on not allowing the individual to speak at that meeting, and we're possibly offside, I think what I'm hearing is that we're offside on not having issued a decision in a timely manner, then do we have much choice than to bring it back and do it again? I mean, it seems to me we've already missed the deadline, and I'm confused as to why, how that happened, and if we should have been meeting in August regardless, would that have, maybe it's a mistake to take a whole month off. I don't know. I'm talking in circles. Back to the original point. If we're offside on deadline and not having had this individual speak, I don't know if we have much choice. I don't know if the outcome will be any different, but it seems to me that this individual ought to have had the opportunity to speak on his own behalf.
Member Glenn, did you want to speak?
Yeah, I'm going to disagree with Councillor Coburn a little bit, and that is the committee did make a decision. A notice of decision should be given, and the applicant has the ability to appeal it and take that before the Ontario Land Tribunal for a decision. Because he didn't get public notice, he got public notice. He didn't get allowed to participate publicly because he erred in where he should be attending. There's a second opportunity for him to do that at Ontario Land Tribunal. Because I don't think, in my own mind, that the outcome of our decision is going to be any different. And so here we are in September, and 2 months have gone by. And because an applicant wrote a letter, we haven't issued a notice of decision. And so I question why we didn't issue a notice of decision. You know, I'm sure municipality gets all kinds of letters of saying, oh, I didn't get notice, or I didn't get allowed to participate. And council doesn't say, oh, well, we're going to go back and start doing that all over again. So my inkling is give notice of decision. If the board, the Ontario Land Tribunal, wants to throw it all out and say, hey, applicant, start all over again, then they'll have to start all over again. But I don't know there's any new information that's going to come before us that's going to change the outcome of our decision. That would be my take on it.
Thank you, Member Glenn. At this point, to be honest, I'm really not sure what our options are for this meeting dealing with that application, other than doing the vote, which is 2/3, I believe Michael said, for the people that were at the meeting, which was myself, Member Glenn, and Member Coburn. So, Michael, would you be able to outline the options that we have?
Certainly, and to you, Chair Gomer, sorry, Chair Latrese. I think the options are one is to reconsider the matter if the committee wished to, and that's would require a 2/3 vote. If the committee doesn't want to reconsider the matter, then I, as the Secretary Treasurer, better hurry up and get a decision posted so that Mr. Thompson can move forward with what he wishes to do, depending on whatever that is.
Okay, what I think I'm hearing is that we should probably do the vote for the people that were there. But at this point, there's been a couple missteps, and the option is there for the applicant to go to the OLT. So there's a couple items. Obviously, the timeline of the notice of decision is one of those things. What is the appetite of the committee members that are able to vote? Does anybody want to comment? Would you like to put this to a 2/3 vote? Member Coburn?
Can I ask a question before we take the vote? And this is through to Michael. The reconsideration of the committee, is it 2/3 of the entire committee present or 2/3 of the committee that was present for the vote?
And through you, Chair Latrese, it's my understanding, according to the clerk's department, that it was 2/3 of the committee members who were present for the vote.
Okay.
I'm thinking that we have an opportunity to do something with this application rather than do nothing. I would be open to voting tonight. Member Coburn?
So thank you, Chair Latrese. I'm just wondering, do we need a motion to put that vote forward? I mean, I'm guessing that the procedure would prescribe that we would need some kind of a motion because we have nothing before us here. What do you think, Michael?
To Chair Latrese, yes, that's correct. I did craft a couple of motions, and just in case. So I suppose the first motion would be to given the receipt of additional information regarding the matter that severance application B0525 be brought back to the Committee of Adjustment for consideration at the November 18th hearing.
Member Coburn?
Did you say November? So we're just skipping on over October, or what? Why would this come back in November? I'm confused.
I was considering the November 18th meeting as appropriate, given that we have to provide Mr. Thompson with time as well to prepare for that hearing. We do have time to get it on the October 8th hearing if the committee wishes.
It seems
do we
to
have a mover or a seconder for that motion?
I would move that motion, but I'm going to ask for the October date because I think I don't know that the individual would need more than a month to prepare for it. I'm not sure why we would put it off until November.
Okay, so for this motion, we would need a mover and a seconder, but we would need them from the 3 members that were at the previous meeting. So Member McMillan, you won't be able to vote for this portion because you were not in attendance at that meeting. So do we have a mover and a seconder for the motion that Michael stated with an October meeting date? So it's moved by Councillor Coburn, and we have no seconder, so that one is out. Michael, can you present another motion?
Yes. The other motion that I had proposed was that upon further consideration of the matter, after receiving additional correspondence from the applicant, the Committee of Adjustment does not support application B0525 as the application does not comply with the definition of a residence surplus to an agricultural operation under the 2024 provincial planning statement.
Okay, can I have a mover and a seconder for that for voting? Okay, moved by member Glenn, and am I able to second that? Okay, and I will second it. Okay, so we will now call the vote on the motion as Michael has stated. All those in favor? And that is carried. Okay. I believe that's all the items. So number 8. Do I need to do anything to close out that last item? Just move on?
Yeah, I believe you can just move on.
Okay, so item number 8 is the next Committee of Adjustment meeting will be on October 21st, 2025 at 5 p.m. If there's no further business, I will now call for an adjournment of this meeting. Can I have a mover and a seconder? Moved by member Glenn and seconded by member Coburn.
Can-
All those in favor? Oh, member Glenn, please go ahead.
Yeah, we can close the meeting. I just have a question following the meeting for Michael.
Okay, all right. So I will call the vote if there's no discussion. All those in favor? All right. Thank you very much. That is carried. And the meeting is now adjourned. Member Glenn would like to speak. So please go ahead.
Just a question for Michael. Congratulations to Ryan Thompson for becoming the new CAO, which was our former chair. Has there been any discussion by council of adding another member to the Committee of Adjustment, or are we going to stay the same until the end of term?
I believe member Coburn has some information on that. No? Oh.
It's probably the same information you were just about to provide, Michael, so apologies, but that will be coming back before council in early next month, I believe. And I do believe, though I'm not 100% sure until council votes on the matter, but the recommendation will likely be to replace Ryan with on this committee with another member of council, given the importance of this committee. Anything to add there, Michael? Did I get that right?
Yes, you did.
Thank you. Just curious. Good choice for the township for the CAO.